coal. Don't be afraid. Don't be scared. It's coal. It was dug up by men and women who work and live in the electorates of those who sit on...
How dare you? You have stolen my dreams and my childhood with your empty words.
Ultimately, the emergency climate comes down to a single number. The concentration of carbon in our atmosphere.
I'm a victim of this whole climate crisis, and I'm not ashamed to say so.
We would like to acknowledge the Wurundjeri people of the Kulin Nation on whose lands we are recording today. We pay our respects to their elders past and present and recognise their continuing connection to the land and waters on which we live. Hi, I'm Danielle.
Hi, I'm Steph.
We will be speaking with Tiphanie Acreman today. So Tiphanie Acreman is a barrister at the Victorian Bar practising in property, land use and environmental law. She grew up in Tasmania and became aware of the role of the law in the environmental context during primary school when the Tasmanian Dams case was handed down by the High Court. Inspired in part by that case, Tiphanie completed a combined Bachelor of Science and Laws with a view to working in environmental policy or law. Her plan succeeded. She has worked at the Federal Department of the Environment, where she was involved in the development of the National Greenhouse and Energy Reporting Act 2007. She has also been an associate to the Honourable Chief Justice Warren, a Monash Law graduate, and the Honourable Justice Judd of the Supreme Court of Victoria. Her time at the court gave Tiphanie the practical grounding in court practice and procedure to successfully read at the bar. Since 2019, Tiphanie has been on the board of directors of the National Environmental Law Association, the peak body for advancing Australian environmental law and policy. She's the current treasurer of that organisation. All right, without further ado, let's dive right in. All right, Tiphanie, I just wanted to say a really big thank you for coming on this podcast, first of all, and really what inspired you to begin pursuing this career and specifically in the area of environmental law.
Thanks, Danielle. Be happy to answer some questions, and I'm happy to have been invited to come and speak today. Thanks. So I grew up in Tasmania, and I grew up, is revealing my age a little. I grew up in Tasmania in the 1980s when the Tasmanian Dams case and the Tasmanian Dams issue was high on the agenda politically in Tasmania. And the Tasmanian Dams case was handed down by the High Court towards the end of when I was in primary school. So really that put environmental law and the power of environmental law on my radar. But I didn't specifically want to be a lawyer at that time. Later, I studied science. So I was studying a Bachelor of Science, and I realised that although I loved being in the outdoors and I was really intrigued by science and the science behind, biology and botany, I realised that I enjoy field work, but I really like to use language more than take measurements and conduct scientific experiments. So I looked for something else that would fit with my science degree, but that would enable me to get more into policy in relation to the environment. And so I chose a law degree because although I didn't want to at that time be a lawyer, I knew that a law degree would be really helpful if I wanted to go and work for the Commonwealth Department of the Environment. And I did that and joined their grad program. However, I realised also that policy isn't really my forte, and I worked for the legal section during my graduate year and realised that actually law is where it's at, and that's really where my passions lay. And so I decided that I would change my dream from being one of working in environmental policy to one of working in environmental law. So that's how I came to be working as a barrister in environmental law.
Amazing.
Yeah, I suppose I would say to anyone looking at getting involved in environmental law or environmentalism generally is that don't confine your thinking to the one goal. If you find that circumstances change and things aren't what you thought they'd be, or you have some ideas about other things that you might want to do, then be open to those. Be flexible. Don't just set your heart on one goal and then only do that goal, only strive towards that goal, because there are many options.
Amazing. Well, thanks, Tiphanie. That's a great answer. I'm just really interested in, obviously, as a barrister, being able to utilise your science degree, obviously without getting into super specifics, and you don't have to. Have you found that it's something that you've been able to utilise and kind of bridge that love that you had for science into being a barrister? Have you found that something that you've been able to transfer across?
Yes, definitely. So part of my role is to cross-examine expert witnesses. For example, I've recently cross-examined hydrologists about flood flows and flood impacts and stream flows and how water interacts with the landscape. And in order to cross-examine an expert witness who's a scientist, it really does help to have a science degree. That also goes for communicating with clients who have science background. For example, when I work for EPA Victoria, often it's the technical scientific people who are giving you instructions. And if you're able to communicate with them from a basic understanding of science, which is all I have because I have an undergraduate degree, but I've never worked in science. But still, I'm speaking their language when I'm speaking to them. I get how science theory works, and conceptually, I can get across scientific material quite quickly. So it really does mean that I'm able to combine the skills that I learnt in science with the legal skills I have now.
Well, I guess drawing on that and from your experience drafting the National Greenhouse and Energy Reporting Act, what skill sets do you think are really necessary or helpful to have in this field of work?
Thanks. Good question. So I was involved in helping to develop the National Greenhouse and Energy Reporting Bill in my work at the Commonwealth Department of the Environment. And that occurred, it was something that had begun development before I joined the department, but was at the policy development stage. So we were interacting with stakeholders, dealing with the different sides of industry and environmental groups to try and work out a way that conceptually we could have a reporting mechanism. And so that phase required good communication skills, a lot of patience. When you're dealing with stakeholders, you need quite a bit of patience and quite a bit of empathy and understanding of different points of view. So you can bring together the different points of view and try and land on a policy position that is guided by principle and takes into account the views and the evidence from a range of different areas. So that was phase one. And then I was lucky enough to be involved in guiding that bill through the House of Representatives and the Senate as well. So that was really intriguing because I was able to deal with the minister and see that piece of legislation move through the upper and lower house, and it was really thrilling, I've got to say. Less of a skill set involved there, really just a support role to advise others as they actually took the active role in putting the legislation through. But it was quite interesting to see the process and how that worked. And maybe it's a little bit political nerdy, but it really was, really a privilege to be able to be involved in that.
Amazing. I guess kind of tying into that, obviously, you spoke a little bit about these two phases, the first being kind of discussions with different stakeholders, and even just like broader industry players, I guess, that were involved in creating this bill to get it into that second phase of moving through Parliament. I guess in this specific piece of legislation, or just even generally as well, what difficulties kind of are there when you're coordinating with a whole bunch of different parties, even generally, I guess?
In terms of difficulties, I suppose policy is always trying to find the right balance between competing interests, and you rarely make everyone happy. You have to accept that not everyone at the table is going to be ecstatic about where you land, but that's not the role of policy. The role of policy is to look at all the differences of opinion and come to a policy position which is of benefit for the community as a whole and takes into account a range of different aspects of a conceptual problem. So I don't know if that was a problem I encountered so much as it just is par for the course with policy. It just requires a bit of working through and a bit of negotiation. But, in the long run, the department is the department, and the government, if it wants to put a policy position through into legislation, is able to make the final decision. So in some ways, they're not seeking to make everyone happy anyway. They have the final say. So it doesn't end up being a problem. But you always want to treat people respectfully, and even if you're not going to agree with their position in the final policy outcome, you want to make sure that they feel listened to and understand where you're coming from in terms of how you've enacted the policy.
Yeah, amazing answer. I think definitely as law students, that's something that we're all trying to grapple with and understand as we move into phases in our career. I guess from that, for those of us that are interested in going into this sector of policy initiative and policy work, do you feel as though there's a part of the process of enacting a piece of legislation like this that maybe the general public might not know about as of yet?
Seeing the way this works from the inside, for me, I found it intriguing, and I didn't know how policy was put into legislation along the way. Of course, I knew that bills were passed in Parliament, but from the inside, what happens is you have a policy area in the department which carries out the policy design in general terms. And then when they're ready, so that's the stakeholder engagement portion, then when they're ready to draft the bill that will be presented to the government, and will eventually make its way onto the floor of the houses, then in fact that's drafted by a separate part of the Commonwealth Government. It's called the Office of Parliamentary Counsel. And so the policy people speak to the Office of Parliamentary Counsel and describe in some detail the outcomes that they want and the mechanisms to get there. And then the amazing people at the Office of Parliamentary Counsel actually do the drafting. And essentially OPC, Office of Parliamentary Counsel, their job is to draft legislation, and they do it very well at the Commonwealth level, certainly. And that's how you kind of put in your information as a policy person, and then the OPC spits back out the draft bill. And then it goes through a series of stages within government to become a bill that the government wants to put out to the House, and then it'll go out to the House of Representatives, up to the Senate and back down to the House of Representatives, and then it ends up hopefully becoming an act. That's what happened with the National Greenhouse and Energy Reporting Act when I was working on it. And so it's an intriguing process.
Amazing. Well, thank you. That's very insightful around, I guess, that large part of your career. I guess moving on to discussing some current affairs that are happening at the moment. A large portion of the Nature Positive plan stems from Professor Graham Samuel's independent review of the EPBC Act. In your opinion, do you think the initiatives such as the establishing of a new independent environmental protection agency sufficiently address the environmental issues we face?
I don't know if it can solve all of the issues around the state of Commonwealth environment legislation at present, and certainly it was only one part of a response to the Samuel report recommendations, but I do think that an independent EPA is a step in the right direction. Regulation. So if you think about the EPBC Act, there are a range of functions that it carries out in terms of assessing projects and the development of plans like water plans and plans for species recovery, etc. So there's kind of a policy aspect, and then there is a development, application and assessment aspect, and then there is a regulatory phase after you issue permits for projects that are already up and running. How do you regulate those? And then there's a regulation of Australia's obligations under international treaties, such as the treaty that Australia's signed up to about the trade in international wildlife, the CITES Treaty. There's all of these functions are lumped into the Department of the Environment at the moment, which, since I worked there, it's been split into two. So they're probably over those two departments now. And I think that if you separate out the regulatory function and give it to an independent EPA, rather than having it lumped in with these other functions that the department carries out, I think that's really going to be a positive step, because the EPA can focus on the regulatory aspect, and that, I think, is something that has been not focused on enough in the past. It's all very well to have laws and regulations and issue permits, but if they're not being complied with, and if you don't have a focus on regulating compliance, then there's not that much point in having the regulations there. So it's compliance that really achieves these outcomes, and also sends a message that that you shouldn't fail to comply, because something will happen to you if you don't comply. So it's a carrot and stick kind of mentality. Now, in terms of how the independent EPA is going to look, I don't think that that's been decided at present at the Commonwealth Government level. But so there are questions around what model the regulator will follow. There are state and territory EPAs, and they follow different models. So I know in Victoria there's a board of directors who oversee the work of the EPA, and that's independent from the EPA staff and the CEO of the EPA. So that's the model that's currently exists in Victoria. I think one of the questions at the Commonwealth level will be whether or not you have a board, or whether or not you just have a CEO to run the department. And that comes with it questions around, can you have an adequately independent CEO who's the repository of all of the power, or should there be a board of a number of people overseeing the functions of the regulator? There are important questions around those issues and how best to implement an independent EPA. Personally, I probably think that a CEO with a board is a better model than CEO alone, but I don't see that CEO alone can't work, just that it might be better from a regulatory point of view to have the oversight of a board. So I think it's the model for the regulator that really is the important question now, now that the government's indicated it will definitely be implementing an independent EPA at Commonwealth level.
I guess keeping on that discussion around current affairs, with the upcoming referendum, there's been an increase in discourse about Indigenous voices in government. And another criticism, of the Nature Positive Plan is the failure to articulate how they would incorporate First Nations engagement and participation. And I guess this stems out more broadly to say, do you feel that Indigenous people are underrepresented in our national environmental law and are disadvantaged in terms of policy making? And what are some of the ways that we can change that?
So addressing the last part of your question about representation of Indigenous and First Nations people in the policy making process, I do think that there's underrepresentation there. And that's part of that stems partly because the legislation was written, it was enacted in 1999. That's a long time ago now. It hasn't had a really serious overhaul since it was written. And that was enacted at a time when there was, firstly, less acknowledgement of the importance of First Nation stewardship of their land. And it was also in the late 90s at a time just post the Mabo decision, the High Court decision, which recognised land rights. And that decision was shaping the political landscape at the time. I remember living through that time that there was a bit of fear-mongering around how this Mabo decision would translate in a practical sense. So, it was said, native title, they're going to claim everyone's backyard, the whole of the middle of Brisbane will have a native title claim over it. It's the end of the world, the sky's falling in. Well, the sky hasn't fallen in because of Mabo, but I think that part of the issue around the EPBC Act and the way it was written is that it was written at a time when there was fear about how Mabo would be played out in a practical sense, and at a time when there was just less of a voice, unfortunately and wrongly, for First Nations people in policy making. So what are some of the ways we could change that? Well, I think that the Nature Positive Plan, I'm trying to guess the government's position on this, but I'd say that the Nature Positive Plan doesn't articulate how First Nations engagement and participation would be incorporated, because we are about to have a referendum on that question. So if First Nations are provided with a voice to express opinions on policy and legislation that affects First Nations people, then it seems to me that that is a really good way of providing for First Nations engagement and participation in the process. And so it doesn't surprise me that the Nature Positive Plan doesn't specifically articulate how that will happen when we're waiting for the outcome of the referendum.
Great answer, Tiphanie. Thank you so much. I guess Pleasure. You were discussing kind of post the Mabo decision that there was quite a bit of fear-mongering around discussions of Indigenous voices and increasing them in Parliament and participation. Do you feel as though with the No campaign this is happening again?
I think it happens in political discourse generally.
Yeah.
I think it's a way that creates traction for a no case, whatever it might be. For example, in the cases that I do around planning permits, one party wants a planning permit, and if you're acting for objectors, then the role is to put the objector's case, and that always involves taking points on small aspects of the case and just creating uncertainty. I think it's actually a political, social aspect of the way society works, and I think that it's not solely related to how the Voice campaign is going. I think it's the way that political discourse occurs. Some say that it's getting worse. For example, the phrase Trumpism comes to mind. I think it's changed because of the amount of wide communication that humans engage in now that we have such easy communication avenues as social media. So once upon a time, if there was a political issue, I might talk to my friends and family about it. I might get some news from print media, a little bit from, the evening news, and the ability for me to do my own research to delve deeply into the issues just really wasn't there without a lot of effort. So that it's a good thing people can research issues now, but with that comes the ability to use these campaigns that are not necessarily based on factual matters, but can be more about fear-mongering. So I think it's perhaps no different. It's just been made more intense.
Yeah, absolutely. Thank you. It's really interesting to hear about the connection kind of between our wider political and social context and how that can apply in your case as a barrister. I don't think that's something that I personally have given a lot of thought to before, so I actually find that really insightful. So thank you.
Sure. Things change over time, right? And there comes a point in your working life where you're just a part of it. You're part of what's going on. So, studying law gives you the ability to really participate in the civil aspects of society around governance. Even if you're solely working in law, it's all about the way society runs, and and even if you're not an environmental activist and you're not working in environmental law, even if you're working at a commercial law firm, you're still involving yourself in those civics aspects of the way policy and the law play out in the general public sphere.
I guess from there, a really interesting case that you've worked on is the Tasmanian Aboriginal Centre and the Secretary Department of Primary Industries, Parks, Water and Environment. Could you share with us a bit about what it was like and what drove you to take up this case?
Sure. So because I grew up and studied in Tasmania, but then moved to Melbourne to come to the Victorian Bar, I did have some friends who worked in environmental law in Tasmania that I'd gotten to know when I lived there and at law school. And EDO Tasmania actually asked me to give some advice on behalf of their client about the potential to bring a case when the Tasmanian government was considering reopening some four-wheel drive tracks. And the four-wheel drive tracks are in the Western Tasmanian Aboriginal Cultural Landscape, which is a listed matter under the EPBC Act. So it was a question about Indigenous heritage values and whether or not driving four-wheel drives through protected areas, including through the middle of middens, and was something that would offend the EPBC Act. Now, when EDO Tasmania asked me to give that advice, little did I know that the case would take, I think it was about 2.5 years to conclusion, possibly 3 years. So I gave the advice and I said, 2014, I'm quite junior. I think I'll need Silk to lead me if this goes into court. So it did go to court. They found a leader for me, Richard Nile QC, who's now a judge of the Supreme Court, and he led me on the injunction. And then we drafted the first claim, which was the claim that kicked off the proceeding in the Supreme Court. So we got an injunction to stop the four-wheel drive tracks being opened over the summer of 2014-15. And then we had to file the case in detail, which we did. it took another year or 18 months, I think, to be heard in the federal court. By that time, Richard Nile was, I should call him Your Honour now, His Honour. His Honour was appointed Solicitor General and could no longer lead me. So Brian Walters QC led me at the hearing, and that was an amazing experience because we got to go in a helicopter with the lawyers from the other side, with members of the client group, the Tasmanian Aboriginal Centre, and the judge to the Western Tasmanian Aboriginal cultural landscape. You can't really drive there. The places we went to, you can only helicopter in or walk in. And it was just one of those amazing experiences of being in a landscape that, where you were just so removed from the post-colonial built form that you could feel like you were stepping back in time. So that was part of the hearing. And then, of course, we won the hearing and the Tasmanian government appealed. And so there was an appeal before the full federal court, and we succeeded on that and obtained a costs order. And I think, 2.5 to 3 years was the whole experience. It's the highlight of the work that I've done as a lawyer because it encompassed everything that I wanted to study for in the first place. There were environmental aspects, First Nations aspects. It was law. I was appearing in Tasmania for the first time in my home state, and it was just really a privilege to be involved in that case. And it just felt great to be able to do something and to do it pro bono for something that I really believed in, which is not always open to a barrister because we take cases on a first come, first served basis. It's called the cap breaking principle. Then you're arguing cases and you don't always agree with, what you're arguing. You agree in a legal sense, but they don't always, the cases are not always something that make you say, wow, I'm really putting in for what I believe in. And that case was something that I strongly believed in, and it was really amazing to be involved in.
Amazing. It sounds like you satisfied your fieldwork aspect of your science degree.
Yes, I did.
A little bit.
I did. So, and we had to call an archaeologist in that case. So I helped prepare a cross-examination of an archaeologist, and we called a historian to give evidence, and I helped prepare the cross-examination of the historian, and then, going out and actually being on country and having a First Nations person who's tasked with the care of that country to explain how to read the land to you is an amazing experience. And if all of my science career had have been able to be like that, maybe I'd be a scientist now, but it was never going to be the case.
Oh, no, it's really amazing to hear when you discuss cases that you've worked on, at the really large intersection between all of these different specialists and the way that they kind of come together and how the utilization of all of their experience kind of culminates into one decision. It's very fascinating.
Yeah, and I think as lawyers we get to work with a range of different professions, so we have a bit of an ability to get across material quickly, even though it's not in our wheelhouse, so to speak.
Yeah.
And it really is intellectually stimulating to be presented with a range of different professionals who are all highly regarded and highly experienced and knowledgeable in their field, and then having to get across that information quickly and cross-examining or calling them as your own witness. So I think to an earlier question, I discussed that I had cross-examined a hydrologist. In that particular case, I cross-examined groundwater, surface water hydrology, noise pollution in terms of vibration, and also airborne noises, really specialist fields.
Yeah.
And I had to try and understand what the concepts were so that I could then build a cross-examination and try and cross-examine someone who's expert in their field, a field which I don't really know about, and try not to be tripped up by them knowing more than I do. So it really is intellectually challenging, and I really love being a barrister. It's just the best job in the world.
Oh, that's really great to hear. I mean, I guess kind of from that, for all of us students who are kind of just really starting out in our degrees, I guess, and just kind of trying to work out what works for us, what's the best for us. For those of us who are wanting to pursue a career in environmental law, either in the policy sector or as, potentially as a barrister, if that's something that they were interested in, do you have any advice for them?
Sure. If you want to go into environmental law or policy generally, then the Commonwealth and state departments of the environment have graduate programs which are really helpful. So I did the Commonwealth graduate program. It doesn't mean that you can't go on and do pure law later, but it gives you a really good grounding. If you're going to be dealing with environmental law and policy, it's a really good grounding to go and see how the government authorities and the regulators work so that you understand from the inside what that process is. Then you can either decide to stay within that system or go out and work in private practice advising private clients, but coming from an understanding of how things work within the government departments. So that's some advice I would say would be my number one tip. There's also internships available at other organisations. Unfortunately, often they're unpaid, so that's not for everyone, but environmental defenders offices Australia-wide, I think, have volunteer programs, although I haven't looked at them recently. And the organisation that I'm involved in, the National Environmental Law Association, has volunteer roles as well in helping to do submissions to government and doing other tasks involved in running the organisation. So you can apply for those positions and do those, but as I say, they're unpaid. Also, I wouldn't say that I wouldn't say you absolutely need a degree in science. That just happens to be something I have, but I know that a lot of people who work in environmental law and policy do not have a degree in science. So don't think of that as a stopper if that's not what you're studying at the moment. Just keep going, keep doing what you're doing, and then aim for some postgrad or shortly before you graduate work that's either paid or unpaid to just get your CV directed towards those areas.
The art student in me is very happy to hear that you don't need a science degree to work in these spaces.
Well, in fact, I've got a friend who worked for the Department of the Environment at state level for a number of years. She's no longer there, but she was someone who studied art science and did not study law, and she's had a very successful career in environmental policy. So you don't really even need a law degree, but I would say that a law degree really does help you along the way because it gives you such a grounding in understanding legislation and so many things that feed into policy. So the law degree is the most important, I think.
Absolutely. To round off our podcast and kind of close today, I just want to ask, though, with climate change and loss of biodiversity advancing at unprecedented speeds, are you optimistic about the future of our environment?
Yes, I am. And the reason I say that is because over a few decades now, I've seen that things change. And although it sometimes feels like things aren't changing quickly enough, they do change. So in the 1990s, it was difficult to even get the environment on the agenda at the top levels of government. And it was seen as somewhat of a lefty or an activist topic that serious people didn't talk about. Whereas now it's an issue and it's on the agenda at all levels of government and also in the corporate world, as well as at the individual level. So things change. Community, business and government expectations have changed. And so I do see that there is hope for the future because we are moving in the right direction. We do need to get our skates on, but it is happening finally.
Amazing. Well, I want to thank you so much for coming on today, Tiphanie. Everything that you said was really insightful and really engaging and honestly quite optimistic to hear as a law student hoping to engage with this space. So I just wanted to say thank you.
Pleasure. Thanks, Daniela. It's been a pleasure to be here.